Thanks for attending this Toolbox Talk on a sunny Thursday morning. This is the one in the series of Toolbox Talks that we're doing on topical HR and employment law matters. And today we're talking about the differences between capability and disciplinary, and the reality of situations that are being faced by employers and those in HR responsibility and management to ensure that they are choosing the right process to deal with situations that are arising when dealing with colleague matters of performance or underperformance, as it may well be. The objective today is to understand the difference between capability and disciplinary reviews, the processes involved, and options to maintain a place of equality, fairness, and trust that fosters strong retention, commitment, and performance results. The objective here is to help employers and managers to understand the differences between capability and disciplinary, and to, in the workplace, ensuring fairness and compliance with UK employment laws. Why does this matter? It ensures all employees are aware of how performance and behaviour issues are handled fairly and consistently. It reduces misunderstandings around capability and disciplinary processes, and they are very different. And it supports better communication and a healthier workplace culture. Capability is defined as a situation, an issue that arises when an employee cannot meet the requirements, the required performance standards due to factors that are outside of their control, such as skills and training, illness, long-term health conditions, and situations still that are out of their control, like family, or if they're a dependent and responsible for care needs. Common examples are, for struggling to meet deadlines due to a lack of training, poor performance related to health issues, or for caring for a dependent that are impeding on their ability to do the job. The right not to be treated less favourably due to an occasion associated disability is afforded under equality laws, and we need to be very mindful of that when addressing underperformance, missed targets, deadlines, timekeeping, attendance, and those kind of things. And the inability to adapt to new technology or processes, not necessarily because of disciplinary matters, but maybe down to capability matters that need to be considered and reasonable adjustments put into place. How is it handled? Capability should be a supportive process, such as additional training, mentoring, reasonable adjustments, or phase plans to return to work. Formal processes only need to be considered if performance does not improve after support is offered. So this can be the precursor to disciplinary action that may lead to the termination of employment, but should be that first step to ensure that any thoughts, any issues that are preventing the employee from achieving what is expected of them are considered and addressed before we reach that first stage of disciplinary action. On the other side, disciplinary issues arise from an employee's misconduct or behaviour that goes against workplace rules or policies. Common examples could be persistent lateness or poor attendance without good reason. It's really important to explore the reasons. Consider that carers' duties may suggest disability by association, may be a capability matter than a disciplinary. So if it is considered a disciplinary matter, be sure to investigate the reasons that you are thinking of taking that stance. There could be a breach of company policy, health and safety violations, or inappropriate behaviour towards colleagues or clients. How are disciplinary matters handled? It's really important to investigate the alleged misconduct. Formal disciplinary procedures, including verbal or written warnings, or in severe cases, dismissal, could be considered. Let's think about verbal warnings. People think that that is a tangible step in disciplinary action, but in those situations, we'd advocate that a performance improvement plan is probably the best way to record the underperformance, the steps that are being taken to address that with timescales, and how it's going to be reviewed, making it very smart. If it is before we get to a formal written warning. As I say, consider the use of performance improvement plans or PIPs as an early intervention and a positive step to take. It will aid any future sanctions if we are heading to formal disciplinary action down the line. We've got evidence to say on this date or dates we've sat down with you and addressed these concerns and put measures in place, offered this support, made these adjustments, and you're still not being able to achieve what's expected to us without due reasons. Communications are so important. Open, fair questioning is fine. Remember, the business still needs to function. Separate absences due to lifestyle, general medical matters against caring for dependents, as employees have day one rights for up to 1 week of unpaid leave protected to take such time off to care for those who fall under their legal right or legal consideration for care. The crux really is the difference between capability and disciplinary action. Is capability comes down to somebody's aptitude, their ability to do the job, compared to their attitude, which have become a disciplinary matter. And the attitude is their choice not to conform or do the job as the role requires, the contract expects, and the business would want them to perform. The key differences between capability and disciplinary issues are that under capability, they're related to skills and competence or health. They are often outside the employee's control. They focus on support and improvement. And we might use a PIP or a form of review to make sure that we are working in harmony to improve the situation. Solutions may include training or adjustments to that role to make sure that person can achieve as the business would accept. On the other side, disciplinary issues relate to behavior, conduct, or policy breaches. They're usually within the employee's control. They focus on consequences for breaking the rules, and solutions may include warnings or ultimately dismissal. Employees have the right to be accompanied through capability issues. They need to be supported, i.e. training and reasonable adjustments. If it does get to a disciplinary matter, they have the right to be accompanied by a work colleague or a trade union representative. But be fair, be realistic about who you might allow to come to that meeting. Anyone but a lawyer, I would suggest. That is particularly the case during formal hearings. All procedures will need to follow the ACAS Code of Practice for fairness and transparency. Your policy, your disciplinary policy, and your staff handbooks should be back to back with the ACAS Code of Practice. The ones we prepare at THSP are fully back to back and compliant. Capability issues are about supporting improvements. Consider a performance improvement plan first. While disciplinary issues deal with misconduct, which could be conditional, setting out some expectations for future conduct and performance. It really is important that we differentiate or understand at the time that the situation arises why it is happening. And again, just to reiterate, if it is a capability matter, it's because somebody just simply can't do the job because of limitations or constraints on them personally to be able to perform to the levels. Then we need to explore that, understand, to avoid any related discrimination or unfair practice. But if it is a disciplinary matter for breaches of rules, general unsupported, unevidenced lateness and absenteeism, then we might be looking clearly at a disciplinary matter. As with all Toolbox Talks, it's really important just to affirm that learning and that understanding. Why should capability be a consideration when dealing with attendance? Is anybody willing to put anything into the chat or open a conversation? So the employee may have a disability, for example, or be associated to someone they care for who has a disability. So it really does need to be explored and understood why that person's attendance is not as acceptable as it could be. Could we give two examples of conduct that could be defined as a disciplinary? One example could be a breach of rules or policy, such as drug and alcohol, or attendance, sickness, absence, or bullying and harassment. Timekeeping without good reason, bringing the company into disrepute could all be examples of disciplinary, fair reasons for disciplinary action. So what processes should be followed when dealing with a disciplinary? As a minimum, the ACAS Code of Practice, your disciplinary policy should be back to back with the ACAS Code of Practice. It sets out the process to be followed, the stages to be adopted, and the rights afforded to the employee during that process. That is as the absolute minimum. And how does capability differ? Capability processes differ by considering the reasons, if there are any medical reports, statements from the employee, GP records, training records, appraisals and performance plans, all before we consider disciplinary or dismissal as a consideration. If there are any questions, I'm very open to stay on this call now, have a private one-to-one in the future, or call me or email me on the details that you have. Otherwise, Emma's going to send out some details, some resources that come along with this Toolbox Talk. It includes the Toolbox Talk, along with an agenda for holding a performance and capability meeting, a disciplinary hearing invite agenda, a performance improvement plan, and a performance plan that deals with capability issues, which is slightly different to a standard performance improvement plan. This recording will also be sent out, so please do share it with your work colleagues and anyone else who you think may benefit. We're going to close this Toolbox Talk now. If there are no other comments, I thank you for attending this morning. Have a great day.